A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a landmark ruling on Wednesday, the Nebraska Supreme Court declared that the state's top election official, Secretary of State Bob Evnen, had no authority to strip voting rights from individuals with felony convictions. This decision has significant implications for the upcoming election on November 5th, potentially adding thousands of new voters to the rolls. The court's ruling comes in response to Evnen's directive from July, which aimed to reject voter registrations from those who had completed their felony sentences. The American Civil Liberties Union, ACLU, estimated that Evnen's order could have prevented over 7,000 Nebraskans from exercising their right to vote, many of whom reside in the pivotal Omaha-centered 2nd Congressional District, a battleground for both presidential and congressional races. The controversy began when Evnen cited an opinion from Attorney General Mike Hilgers, which deemed a recently passed law unconstitutional. This law restored voting rights immediately upon completion of felony sentences, a change that was met with resistance from the state's Republican leadership. Justice Lindsay Miller-Lehrman, in her opinion, criticized Evnen and Hilgers for attempting to unilaterally declare the law unconstitutional, highlighting the importance of following the legislative process. Do we want to live in a world where every state employee who has a hunch a statute is flawed gets to ignore it? She questioned. Nebraska, while predominantly Republican, is one of only 2 states that allocates its electoral college votes by congressional district, making the Omaha area particularly significant. The district has previously awarded electoral votes to Democratic candidates, including Barack Obama in 2008 and Joe Biden in 2020. With the 2024 presidential race expected to be closely contested, the added voter registrations could prove crucial. Following a redistricting in 2021, registered Republicans outnumbered Democrats by over 13,000 in the 2nd District, but the presence of nearly 114,000 independent and third-party voters complicates the political landscape. The ACLU's lawsuit, which was expedited to the Nebraska Supreme Court due to the impending election, represents advocacy group Civic Nebraska and 2 residents, Jeremy Jonick and Gregory Spung, both of whom have felony records and would have been disenfranchised under Evnen's directive. Jonick expressed relief at the ruling, emphasizing the importance of giving individuals a second chance to participate in democracy. Spung echoed this sentiment, stating, "Today's decision reaffirms the fundamental principle that every vote matters." The ruling also touches on broader issues of felony disenfranchisement laws, which have roots in the Jim Crow era and disproportionately affect Black individuals. While many states have made strides toward restoring voting rights, approximately 5.85 million Americans remain disenfranchised due to felony convictions. As the election approaches, the urgency of the situation is palpable. The last day to register to vote in Nebraska is October 25th, and all registrations must be completed in person. The decision from the Nebraska Supreme Court not only restores voting rights to thousands, but also sets a precedent for future discussions on electoral access and the rights of individuals with felony convictions. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.